Your assets are typically distributed in one of three ways: by law, by contract, and by probate. Law means there's a law on the books, either locally, federally, in your state, that says this asset is going to pass according to this law. A lot of times our properties, those are dictated, how they pass is dictated by law. So for instance, if I own a property with my spouse jointly with rights of survivorship, that is a legal term. That legal term means when I pass away, the house automatically belongs to my spouse, 100%. There's no ifs, ands, or buts. No random people can come out of the woodwork and claim ownership. It does not go through the probate process. No one can contest that my husband is now the 100% owner of this property. He's able to stand firm in that legal standing, because there's a law that says if you own property jointly with rights of survivorship, the other person automatically becomes the owner. And law trumps contract, law trumps probate. So the reason I say that is I have been in a situation where husband and wife own a property together, jointly with rights of survivorship, but there was an old will whereby husband said, when I die, I want my house to go to my brother. The reason the will said that is because when this gentleman made the will, he hadn't remarried. So he was not thinking of his wife at the time, because there was no wife at the time. So he was thinking of the immediate persons who were in his life at the time. He loves his brother, of course. And he said, okay, when I'm not here, my brother gets the home. He later married and then titled the home jointly with rights of survivorship, forgetting to go back and adjust the will. Now, when he passes away, of course, jointly with rights of survivorship trumps the trust and trumps contract. So brother thought that he was going to get the house, but he was mistaken. And we had to tell him, actually, the law trumps in this situation. So even though this was your brother's written intention, signed, notarized, valid will, the whole thing, his will does not trump law. So if you have properties or you have family members, parents who own properties, it's good to look at the titling. Is it owned jointly with rights of survivorship, which means it automatically goes to the other person? Is it owned tenancy in the entirety, which means it also automatically goes to the other person? Is it owned in another format, usually in a single format where each person actually owns 50%? So let's say me and my husband owned it in that designation, tenants in the common. When I die, my 50%, I can make it go to anyone I want. It doesn't automatically go to him. So I could have something in the will that says when I pass away, 50% of my ownership in this home goes to my brother or my mom or my best friend. So now that creates a situation where my husband now no longer owns the home 50-50 with me. He owns it 50-50 with my brother, my sister, my mom, my best friend. So reviewing the title of your assets will let you know how the assets are to pass. And if it's titled in the way that you do not want, then you can go ahead and change that. So assets that pass by operation of law, they know exactly where to go. There's a legal standing somewhere that says you go here, you go there, no ifs, ands, or buts about it. Then there are assets that pass by operation of contract. Similar to the law, there's something in writing. The parties have agreed to it and have said, this is how this is going to happen. The most common example are our retirement plans, our financial instruments that have beneficiary designations, your life insurance policy that has a beneficiary designation. So if I have a life insurance policy and I've named my husband the beneficiary of that policy, that goes to him. So even again, if I've named my brother as the beneficiary in my will, my brother does not collect that death benefit. It goes to my husband because there's a contractual obligation. I've already written long time ago that when I pass away, my husband is going to be the 100% beneficiary. Same thing with the 401k. I might name my husband as the beneficiary of the 401k. Or I have a checking and savings account at Bank of America. I might put a beneficiary designation on that and say, when I pass away, whatever's sitting in these accounts goes to my brothers equally. That's contract. So knowing why or how an asset passes is very important, because it's important to know where it fits in the estate planning process. If I have a client that has everything that's going to pass through operation of law or operation of contract, there's not much complicated estate planning documents that I need to create on their behalf. I'll still create a will, but it's unlikely that they need the other documents.